When you think of a trial, your mind probably jumps to those dramatic courtroom showdowns you see in movies, right? Surprise witnesses, lawyers shouting objection. But the truth is, what really wins a case is a whole lot less spontaneous and way more strategic. Today, we're opening up the lawyer's playbook to show you how trials are actually won. And, spoiler alert, it all happens behind the scenes.
So what is that secret weapon? Is it some brilliant, last-minute closing argument? A devastating cross-examination that makes a witness break down on the stand? Well, you might be surprised to hear that the battle is often won long before anyone even steps foot in a courtroom. The real key? It's all in the painstaking preparation that starts months, sometimes even years before the trial.
And this quote right here just nails it. Winning a trial isn't about one single moment of brilliance. It's about building your case, piece by piece, on this solid foundation of really diligent, early work. So where does that foundation actually get built? Let's dive in.
Okay, first up, the foundation. This is where the entire case really takes shape. It's the strategic phase, where the story gets written, the arguments are framed, and the path to victory is basically mapped out from start to finish. And it all starts right here, at that very first meeting with the client. Look, this is so much more than just a get-to-know-you chat. It's the beginning of the entire investigation. Every single decision from this moment on is built on the information you gather and the strategy you develop in these initial stages. Getting this part right can totally change the outcome, and getting it wrong, that's a mistake you just can't come back from. Now, at the heart of all that strategy is this really critical concept, the theory of the case. You should think of it as the master narrative. It's not just a pile of facts. It's a compelling story that explains what happened, why it happened, and, most importantly, why the jury should find in your client's favor. Every single piece of evidence, every question you ask, every argument you make has to support this one consistent theory. Seriously, going to trial without one is like trying to build a house without a blueprint. It's just going to fall apart. So, a really strong case theory does a bunch of things at once. It has to weave together the facts that everyone agrees on with your client's version of the facts that are up for debate. It creates this cohesive, logical story that shines the absolute best light on your evidence. And this part's key. It also has to account for the strengths and weaknesses of both sides. Ultimately, your goal is to give the jury the single most plausible explanation of what really went down.
Okay, so once you have your story, you've got to build your arsenal. This is the nuts and bolts part of the job. Gathering the evidence, the documents, and the testimony that are going to bring that case theory to life in the courtroom.
This whole phase is called discovery, and it's the formal process where both sides are basically forced to show their hands and exchange information. The big idea here is to understand the full scope of the case and, crucially, to avoid any surprises at trial. That's a huge rookie mistake. Forget the gotcha moments you see on TV. In modern trials, everybody gets to see everybody else's evidence. It lets you prepare your arguments and, just as important, your counter-arguments. So what does this evidence gathering actually look like? Well, lawyers use several key tools. They'll request all the relevant documents, emails, contracts, you name it. They gather sworn statements from witnesses, they get their hands on physical evidence for inspection, and they bring in experts to compile reports on things like forensics or medical exams. This is where you get all the raw materials you need to prove your case. And this brings us to an absolutely critical point. All of this information, documents, statements, reports, it's all completely useless if it isn't meticulously organized. The real command center for a trial isn't some high-tech war room, it's the case file, often put together in what's known as a trial notebook.
So what's actually inside this thing? Well, it's all methodically divided into sections. You've got a section for all the formal court documents, another with detailed outlines for questioning every single witness, a log of every piece of physical evidence, and even memos on legal research for any tricky issues that might pop up. This organization is what lets a lawyer find any piece of information in a split second during the heat of a trial.
All right, so with all that prep work done, let's finally step into the arena. The trial itself is the performance. It's the ultimate test where all that careful planning and prep are put into action in front of a judge and, of course, a jury.
First off, it's really important to understand where we are. Almost all cases start in a trial court. This is the court you're used to seeing on TV, the one that hears from witnesses and looks at new evidence. Its entire job is to figure out the facts of the case. Now, appellate courts, they're totally different. They don't hear new evidence. Their only job is to review what happened in the trial court to see if any major legal mistakes were made. So what does a trial actually look like, step by step? Well, it follows a pretty structured sequence. It all kicks off with jury selection. Then, both sides give their opening statements. This is the first time they introduce their theory of the case to the jury. After that, you get to the core of the trial, presenting evidence through witnesses. And finally, the lawyers make their closing arguments, wrapping everything up for the jury, who then goes off to deliberate and deliver a verdict.
So what you have to remember is that a successful trial isn't just about good acting or a powerful speaking voice. It is the direct result of months and months of strategy and painstaking preparation. Every single question asked, every exhibit shown, it's all part of a carefully constructed plan designed to tell that one persuasive story we've been talking about.
But that brings up a great question. What happens when the jury delivers its verdict and the legal battle still isn't over? Well, that brings us to the next stage in the playbook, the appeal.
And that brings us to the aftermath. If the party that lost believes a serious legal error was made during the trial, they can ask a higher court, an appellate court, to review the whole case. And believe me, this is a whole new fight with its own unique set of rules and procedures.
Yeah, the appeals process is very formal, and it moves along a really strict timeline. It all kicks off with filing what's called a notice of appeal, and you've usually only got about 30 days after the verdict to do it. Then for the next few months, both sides write these long, detailed written arguments called briefs. After that, there's usually a pretty short oral argument in front of a panel of judges. The whole process, from filing that first notice to actually getting a decision, can easily take a year or even longer.
So after all that, what can an appellate court actually do? Well, they have a lot of power. They can affirm the original verdict, which means it stands. They can reverse the decision completely, literally turning the loser into the winner. They might modify the outcome, maybe changing the amount of money awarded. Or they can remand the case, which means sending it back to the trial court for a do-over on certain issues, or sometimes even a whole new trial.
But here's something that is so important to understand about appeals. The appellate courts, they aren't looking for tiny little imperfections. They are searching for significant legal errors, mistakes that were so big they likely changed the outcome of the case. Just a small procedural slip-up, that's almost never enough to get a verdict overturned. The standard is a fair trial, not a perfect one. Which brings us all the way back to our main question. While a little bit of courtroom charisma definitely helps, a trial victory is almost never about one single dramatic moment. No, it's the culmination of a long, deliberate process of building a case, of building a story, on a foundation of meticulous research, organization, and strategy. In the end, it's the script, not just a performance, that truly wins the day.